Your Excellencies, Attorneys General, Chief Justices, my lords and ladies, distinguished guests, ladies and gentlemen, welcome to the second day of this, the 23rd Commonwealth Law Conference. Just a couple of brief housekeeping announcements before I leave you in the capable hands of His Lordship. The buses will leave on the hour and a half hour backwards and forwards to the other conference hotels. If you're there 5 minutes after the hour, you've got a 25-minute wait. It tends to follow, doesn't it? Ladies and gentlemen, there is a lunch today is hosted by the Americas Hub, and the Vice President for that hub, Laurie Politzer, invites you to join her at the Chula restaurant for matters of interest to those of you from the Americas, but indeed it's open to all delegates. Tomorrow morning there is the International Women's Day breakfast, which is in Ballroom 3. That's right next door to this, and again, you are welcome to attend that. And finally, and probably most importantly, Peace at the Crease. The cricket match on Thursday is still looking for a few cricketers to join the teams, and if you are interested in doing that, and if you fancy yourself as a bowler on English wickets, which I must say I'm not, please see Santan later on. It's now with great pleasure that I introduce the very distinguished chair for this particular session, and thank him for agreeing to do that. Ladies and gentlemen, the Lord Chief Justice of England and Wales.
Right, everyone. I'm sorry to disappoint you. I'm not the Lord Chief Justice of anywhere. My name is Robert Carnwath. I was a member of the Supreme Court of the UK until 3 years ago. I'm happy to see the Lord Chief Justice sitting in front, and no doubt he will get up and tell us all about this in due course. I've been brought in at relatively short notice to chair this event, for which I'm honoured. I confess that when I look at the title, Plenary Panel to Living Lands, How Should Lawyers Answer the Call? My initial reaction, seeing that, was, what had living lands got to do with us? Indeed, what was it? And I did a sort of straw poll around people in the conference and said, did they know what living lands were? And I didn't find any of them who knew, let alone what lawyers should do to respond. But in fact, this is a very important issue. The Commonwealth Living Lands Charter was adopted by the heads of government of the Commonwealth last year in Rwanda, and there you see the impressive cover, and it does indeed talk about the commitment of our Commonwealth countries to the sustaining our lands and to all the various conventions that have been put in place for protecting the environment, for fighting climate change, and so on. We'll come to the text in a moment. We were to have had the Minister of Labour and Employment Environment to speak, but unfortunately he's not been able to come. And so instead we have you have me chairing it, but we also have a very distinguished panel. We have Fiona McLeod, AOKC, who is a senior counsel practicing at the Victorian Bar in Public and Commercial Law, co-chair of the Diversity and Inclusion Council of the International Bar Association and officer of the IBA Bar Issues, past president of the Law Council of Australia, and indeed many other honours, including the Order of Australia. She's going to start by talking about how she sees the aspirations and what they mean in practical terms. We then have Melinda Janki, who is a lawyer from Guyana, who has a small firm there which is very active in the environmental field, and she has been involved in many cases challenging the abuse of the environment, and particularly in facing up to the vast power of some of the major oil industries who have been seeking to exploit the oil resources of that country. And then thirdly, for the Indian perspective, we have Shyam Divan, who is a senior advocate practicing before the Supreme Court of India with a very extensive experience of constitutional cases and environmental cases in that tribunal and generally. And he's also the co-author of the Environmental Law and Policy in India, Cases and Materials, 3rd edition. So that's the lineup. We've got until 10:15, but at about 10, I'm going to break because we have the president of the Sabha Law Society who wants to present a short video about a conference that's being organized in that rather beautiful country. Now, before I invite the speakers, I just want to perhaps introduce those of you who are not totally familiar with it, to the Commonwealth Living Lands Charter. It has a nice cover, as you see, and it then has, as some of these documents tend to do, a rather long preamble which tells us about all the things that are acknowledged or noted or recognized. It goes on in that vein. Importantly, in 5, it reaffirms, you may not be able to read it, but it reaffirms a commitment to the Paris Agreement and the commitment to holding the increase in global average temperature to 1.5 degrees. And then it goes on noting and recognizing and recalling various things. It's wonderful how these sort of words change. They're all emphasized, but whether there's any difference between affirming, recognizing, and noting is not very clear to me. But in any event, the 12 is quite important. That is a reference to the 3 Rio Conventions, the Convention on Biological Diversity, the Convention to Combat Desertification, and the Convention on Climate Change. And those are the 3 Rio Conventions which are affirmed by the Commonwealth. And then it notes various things. It recognizes, interestingly, that 54 community countries have coastlines. 47 of the 54 Commonwealth countries have coastlines, and 45% of the member countries are large ocean states, thereby requiring an inclusive approach to sustainable land management in the coastal areas. And then it goes on to recognize and note and welcome various things. And we can skip over that. Paragraph 19, we have a slightly different language. We underline the pressing need to implement international and regional commitments, and we recognize various things, and so on and so forth. Sorry, jumped over there. And then on the next page, we underscore the 16 principles contained within the Commonwealth Charter, and the 17 Sustainable Development Goals are relevant to meeting land-related commitments. We underscore commitments member states have made in the context of the Rio Conventions, and recognize the need to take a consistent approach to the principles of the Commonwealth Charter. And then 30, we voluntarily dedicate a living land to the future generations of every Commonwealth country with assured prosperity, sustenance and security in line with the strategy set for the UN Decade on Ecosystem Restoration. And then finally we come to implementation, and there we endeavor to work towards climate resilient and sustainable land management in member countries by integrating the goals of the 3 Rio Conventions towards catalyzing progress in achieving the Sustainable Development Goals, and so on. And then 32, finally, we get something mandatory, which is we mandate the development of an implementation plan for CALL, for consideration of Commonwealth members. So there we have it. Now, I did ask tentatively what happened to this implementation plan, and I hope that perhaps before the end of the session, our representative, Mr. Louis Franceschi, who's sitting over there, will tell us how they're getting on. He's a senior lawyer at the Commonwealth. But before we get on, there's the other one which is actually mentioned, which it was also part of the subject of this session, is the so-called Declaration on Sustainable Urbanization. And if need be, we can get it up onto the screen. But I think it doesn't, again, it's rather an affirmation of pre-existing goals to the need for what are called integrated strategies for safe and sustainable urban development that enhance community well-being and security. And it's all about the process of urbanization. But it's a one-page document. It doesn't have a great deal of detail on how that's going to be achieved. And it may be that Louis will be able to tell us how that fits in to the implementation plan. So that's the sort of framework we're discussing. And I'll hand over now to Fiona, who will start us off. We've got slightly less time than we originally anticipated, so I hope that the speakers will be able to keep to not more than about a quarter of an hour each, which will leave us a little bit of time for discussion before we move on to the President of the Law Society of Sabah. So over to you, Fiona.
Thank you very much, Your Lordship, the other Your Lordship, and good morning, everybody. Thank you very much for your introduction. I'm delighted to join this esteemed panel, and can I offer my congratulations to my fellow panellist, Melinda, for her very well-deserved award of the Commonwealth Rule of Law Award, for her remarkable work in West Papua and Guyana. Her work is a perfect example of the question raised by this session and the role of law and lawyers in the protection of the world's precious resources. Melinda's work and other cases that I will mention this morning emphasise the important role of lawyers in the development of international law and domestic responses to address critical needs raised by the Living Lands document. They include the need to safeguard global land and water resources for future generations, to take coordinated action to address climate change, biodiversity loss, and land degradation and desertification, to promote climate resilient and sustainable lands management, and to pursue the objectives of the 3 Rio Conventions and Sustainable Development Goal number 15. And yesterday, in one of the sessions on terra nullius, we heard another example of the work of lawyers in protecting the rights of First Nations peoples, their rights to their land and livelihood, in a session on terra nullius, as I've said, and it was the work of lawyers, academics, judiciary and lawmakers, including the remarkable work of our former Australasian VP, Stephen Thiru, and his colleagues on the Orang Asli case. There is a lovely irony, I think, that the common law system that has deprived our First Nations peoples of their lands and culture is now being used to hold those governments to account. Nevertheless, the common law offers many opportunities for the lawyers and those in the room to use the common law and to use their role influencing lawmaking to make a difference in this space. So this morning we're going to reflect on the implications of the Living Lands document and these multilateral agreements and the attempt to respond to global threats of unsustainable land and waterways use, stripping precious resources and the pressure of unrelenting urbanisation and greenhouse gas emissions. I want to first recognise that these issues have been the subject of international conferences for more than 40 years. Those conferences have warned of the dire consequences to our planet and our way of life unless greenhouse gas emissions and our consumption's habits change. Yet here we are, on track for more than 3 degrees of global warming and all of the things that go with that. The extinction and extreme stress placed on all species, the increased frequency and intensity of disasters, droughts, fires, cyclones and desertification, the heating of the environment to lethal levels, including for human beings, the death of the world's coral reefs, living organisms that sustain us and all life in the oceans, pollution of and limited access to clean water, and impacts on our public health systems and our own physical and emotional and spiritual well-being as human beings, dependent on all other species for our own survival. And I want to pose this question: how can lawyers not be part of the solution? First of all, we are problem solvers by nature and by training. And secondly, we have the tools and the wherewithal to take on, one case at a time maybe, or in regional and global settings, the changes that we desperately need to see in the world. So my question to you is really one that I hope fires your own imagination. What new rights of action are available to us? What can we take on? And to suggest that what we will see in future is really only limited by your own imaginations. Now, I'm going to ask you, because it's quite early in the morning, to participate in a small survey. And in a minute, I'm going to ask you to raise your hands if you've done any of the following things. Have you ever advised a client about pollution and preservation of land, water bodies, and resources upon which lives depend? Have you ever advised a government or corporation about their rights and obligations to limit, remediate pollution or report on their operations, to tell the truth to the market and the general public or to partners about the impacts of their plans and their operations upon biodiversity loss, the degradation of natural resources, greenhouse gas emissions from their activities or planned activities, or engaged with their risk management of exposure to climate change and other environmental risks? Have you ever been involved in litigation or other dispute concerning human rights, including right to life, to a clean environment, to housing, to food and other derivative rights, or constitutional rights or other causes of action to hold a party to account? Have you ever acted for First Nations peoples in matters concerning the loss of lands, livelihoods and culture protected by laws that aim to preserve traditional practices? Have you ever engaged in developing, determining or commenting on local laws and international agreements concerning any aspect of these things, domestically or across borders, including seeking compensation for those affected? And have you ever been involved in any other way in protecting the Earth's precious resources and biodiversity or addressing climate change? So now, if you wouldn't mind just raising your hand if you've done any of those things or something close to it. Well, that actually, just look around the room and you'll see that probably more than half the room have their hands up. So now can I add a final question to you? Have you ever attended a conference session where these things have been discussed? And do you plan to attend the Committee of Climate Justice tonight at 5 o'clock? That should be all of you, right? So just a reminder to reflect on where the Living Lands document came from. 32 of the world's 42 smallest states are Commonwealth members, each with a population of less than 1.5 million citizens. 2.5 billion of the world's 8 billion inhabitants live in Commonwealth countries, and as we know, many of them right here in India. The Commonwealth and Commonwealth lawyers and our affiliates are uniquely placed to make a difference, not just because of the size of our population as a percentage of the world's total population, but because we represent, or the Commonwealth represents, some of those small nations who are most severely and directly impacted by the effects of environmental degradation and climate change. The recent CHOGM communiqué notes Land, including its water bodies, is both the source and sink of greenhouse gases and supports billions of people for their food, livelihoods and well-being. The Earth's climate is changing at an alarming rate, and the associated impacts and risks are being felt increasingly across a range of terrestrial ecosystems which are essential for nature and people. Unsustainable land use, combined with increasing climate extremes, have a direct impact on the destruction and degradation of soils, forests and biodiversity in many countries, and pose a high risk of land-related natural disasters and extreme depletion and contamination of groundwater sources, which affect the health of millions of people, particularly the most vulnerable groups, including youth and women, including increases in environmentally induced migration. So we have a clear responsibility and a clear obligation to future generations who will inherit this world from us to lead the conversation and to push in the development of legal rights and remedies. I wanted this morning to share with you a case that I'm leading in Australia, which is seeking to hold the government to account for its failure to protect the peoples of the Torres Strait Islands. The case is Pabai and the Commonwealth, and it's being brought in the federal court. Torres Strait Islanders, whose homelands are the islands, reefs and waters of the Torres Strait, are especially vulnerable to the impacts of climate change. They already experience the effects of climate change by way of sea level rise, including storm surges, coastal erosion, inundation and flooding of their villages, contamination of freshwater sources with salt water, and they observe the effects of the ocean warming and acidification, coral bleaching and degradation of the marine environment. The projected impacts of climate change are far worse. They, as with so many small island states, face an existential threat from climate change. The applicants in that case, who are representatives of the class, allege that a special relationship exists between the Commonwealth of Australia and Torres Strait Islanders, and that creates a duty of care owed by the Commonwealth to act and protect against the harm that climate change has caused and will likely cause to Torres Strait Islanders' health and safety, their lands and seas and their way of life. So the two uncles, Pabai Pabai and Guy Paul Kabai, have commenced the proceeding as a class action on behalf of all Torres Strait Islander people who have suffered or may suffer loss and damage as a result of the Commonwealth. Pabai Pabai and Guy Paul Kabai are Torres Strait Islanders. One is 52 years of age and the other is 54 years of age, and they both hold native title rights and interests in the islands of Boigu Island and Sabai Island, respectively. So I don't know how many of you know anything about the Torres Strait, but this is an area of land and sea between the Commonwealth mainland and Papua New Guinea. And the islands, some of them are very, very close to Papua New Guinea, but because of the treaty between Papua New Guinea and Australia, a line is drawn around the top of those islands, pretty much just south of the coast of Papua New Guinea, such that they are now part of the Australian nation. The islanders hold native title or native title rights and interests to various parts of those islands, and they have a distinctive culture known as island custom, which includes a unique spiritual and physical connection with the Torres Strait Islands. Because the small and low-lying islands in some cases are less than 2 metres in height above the sea level, they're particularly vulnerable to the impacts of climate change. Some of the islands are a little higher, but they are already suffering significant coastal erosion by changes in the sea patterns and tides. So many sections of villages in the Torres Strait are literally just above the high tide, and they regularly flood. Indigenous people of Australia are disproportionately vulnerable to harm from climate change, including by reason of their location close to the coast, their occupations, their connections to land, and environmental, social, and economic disadvantage. So the case, which will proceed in June, will first of all hear evidence from the what we call the lay evidence, the members of those islands who talk about the loss of culture and impact and their observations of climate change on the islands. And then later this year, there will be a block of hearing from renowned experts speaking about the impact of climate change in the Torres Strait. In essence, the duty of care, which was inspired by the Urgenda case where Urgenda sued the government of the Netherlands, allege a duty of care to care for those residents of the Torres Strait. Now, in Australia, we don't have constitutional protections for human rights. I know that's quite a stunning thing to say in an audience like this, but we don't. Nor do we have any legislative basis for those Torres Strait Islanders to bring claims under the Constitution or human rights legislation seeking to protect their human rights. There was a claim by a group of Torres Strait Islanders to the Human Rights Committee, known as the Torres Strait 8, alleging breaches of their of their human rights, which was successful, and the committee has criticised the Australian government for its failure to act on climate change. But as we all know, those committee responses do not mandate a response by the Australian government. If they choose to ignore that ruling, they're free to do so. So apart from the diplomatic pressure that can be brought to bear against Australia for its refusal to acknowledge and act upon the criticism of the Human Rights Committee, what is left to us? The duty of care that we framed in our case says that the Commonwealth Government has a duty to protect its First Nations peoples from their vulnerability, essentially to an existential threat. And it's framed in two ways. The first is that there is an obligation to act essentially rationally by paying heed to the best available science in designing its response. We don't tell them how they're supposed to respond because that is forbidden under our line of authorities as a matter of high policy, but we do say they have an obligation to protect and to act rationally. And the other way is that we put the duty as a duty to take adaptive measures. And incidentally, the Commonwealth has built seawalls throughout the Torres Strait, and you could spend $20 million on a seawall which would protect a kilometre or so of a village on one of these islands, and within 5 years the tide is coming over the top of those seawalls and they're being eroded. So the Commonwealth has weighed in and taken some protective measures, but essentially for some of these islands the reality is they're looking at relocation. So that's in a nutshell what the duty of care is, and that they failed to take into account and engage with the best available science on emissions to protect Torres Strait Islanders. The applicants seek declarations, including that the Commonwealth has failed to act and, as I said, have issued proceedings as a class action. Sorry, for some reason my microphone just turned on and spun me around the document. So much for the legal framework. The power of a case like this, and cases that I know are springing up across the Commonwealth where lawyers are acting to protect the interests of First Nations people, first is that we hold the government to account for its failure to protect its citizens from an existential threat. And philosophically, this surely must be the fundamental obligation of government. This surely must be founded in the social contract between the government and its citizens, that the government will act to address an emergency that threatens the lives and livelihoods of its citizens. And secondly, the advantage of a case like this is that it allows our First Nations people to speak directly to the courts and thereby to the governments to shape the development of the law in a very powerful way. So I want to finish by reading to you some of the evidence that will be tendered to court in this case. And just a rider, bear in mind the evidence is not yet before the court, but it has been served on the government, so I'm confident it's appropriate.
Fiona, I think we need to be drawing to a close very shortly.
Yes, thank you. Sure. I'll just read you a couple of passages, if I may, Your Lordship, about this evidence. I'm a traditional owner and native title holder from the Badigal Nation in Zendath Kes, the Torres Strait. I'm 48 years old. I have 9 children. My wind is Nagai Northwestern. My totem is the Papuan black tiger snake. Forgive the language. If you piss it off, it will chase at you until it gets you. That is one of the traits of my family. We don't give up. I live in an island raised on a property that my father built. It's situated on a higher area of the back of town. Even my land now floods in the high tide. Culture or island custom means to me existence and life. In any society, language will give you identity. So culture gives you roots and a way of life that makes you different from another culture's practice. Then you exist that way. Those things go together. That's your lifestyle. In the Torres Strait, my culture and my existence together gives me my lifestyle. He talks about death rituals and he talks about his learnings as a child. As a child, suddenly you'd hear a big school of birin birin, the rainbow bee-eater bird. They'd whistle and you could hear them. Then we would know it was turtle mating season and teach our children to be ready. Our artwork reflects this. It's important to understand this because when we see these signs, we teach our children to prepare for turtle mating and make plans to collect the eggs for special meals. But when the trees and the animals and other signs are confused, we can't teach them and pass on our culture in the way that these steps are read and should happen. And skipping ahead through his beautiful statement, I'll finish with these words. We live on an island that's changing. It's not our fault that the climate is changing. We are the least polluting people in the world. Everybody else is polluting the planet, like mainland Australia, and we're getting the effects. We've been struggling all our lives. These things on top, what do we do? When this cultural education system has been undermined and threatened by climate change, we lose our powers as teachers. I can see in the future when our kids think about culture, it will just be an echo, not important. I want to make sure our culture is continued here. We're doing this so my kids and those who haven't been born yet will be born into something that's been going on a long time. If I was you and you were me, knowing what you know now, what would you do? Thank you.
Good morning. It's wonderful to see you, and I'm really honored to be part of this distinguished panel. Living lands, how should lawyers answer the call? Great question. With your permission, I'd like to give some examples of what this could mean. Please come with me on a journey. Use your imagination. Let's go thousands of miles west to South America, to my country, Guyana. I invite you, in your imagination, into my home, an old wooden house in Georgetown, the capital city. Cool sea breeze. I grow flowers and food on my windowsills. In the bedroom is an old china teapot I bought in Hong Kong years ago. My teapot became a little flower garden, and if you looked carefully enough, you could see a little family of tiny frogs living among the stalks. A few inches from the windows, hibiscus flowers with hummingbirds. My garden is tiny, but I have 100 trees. Everything grows on top of everything else. They're the other part of my lungs. I breathe out carbon dioxide. They give me back oxygen. It's full of life, my home. In my house, birds, lizards, butterflies, bees, beetles. At nights, the bats fly up and down, candleflies flash green lights, and the opossums dance on the roof. The trench outside has fish, and if I'm really lucky, sometimes the little snakes that we can catch. Actually, I'm too slow. My gardener, who is like a brother to me, Lennox, he catches them, and we admire them and put them back into the water. This is a tiny living land in the middle of a capital city. A possible response from a lawyer to the call for living lands. But what about responding as lawyers? We have particular skills. Let's take another journey and go back a few years in time. Guyana decided to do a new Environmental Protection Act. I made a bit of a nuisance of myself saying the draft wasn't good enough, and I was lucky to be retained to rewrite it. Today, we have the Environmental Protection Act, which we can use to respond to the call for living lands, protecting our land, soil, water, ecosystems, ocean, forests, etc. And a few years later, I was again lucky when I was asked to draft a new law for Guyana, a Protected Areas Act. Protected areas are a good way to halt and reverse biodiversity loss, one of the concerns of the call for living lands. Both the Environmental Protection Act and the Protected Areas Act seek to protect natural capital, the land and the life on the land that sustains us physically, mentally, spiritually. Life is not just material, it's also spiritual, and we have a spiritual connection with the earth and the life that shares this earth with us. And the Act recognizes the intrinsic right, the intrinsic value of biodiversity and its right to exist, and our associated cultural and spiritual values. Colleagues from Australia may also recognize references to ecologically sound, sustainable development within the limits of the planet. Another possible way to respond to the call for living lands. The call also mentions Indigenous peoples. This is a very contested area of law. But in Guyana, we found a workable solution. The Amerindian Act is a direct response to the demands of Amerindian peoples themselves. This time I was really privileged to be chosen by Amerindian leaders to write this law, and I was doubly fortunate that the minister, Carolyn Rodrigues, was a brilliant young woman who was herself Amerindian and politically very astute. Today, all Amerindian communities have guaranteed rights to land, control access to minerals, can stop destructive mining, have collective title, communal title, absolute title, title forever. Their land can never be taken away, and it's protected by the Constitution. There's a process for settling land claims based on traditional occupation and use, and, you guessed it, cultural and spiritual connections. Amerindian peoples have the power to take care of their land in accordance with traditional knowledge and the UN Declaration on the Rights of Indigenous Peoples, as specifically referenced in the Commonwealth Call. So another possible response to this call is to lobby for new laws, to influence the content of those laws, and to draft laws that are consistent with the call and further that call. But law is not simply a drafting exercise. We have to use it. The Amerindian Act was 2006. The following year, the YY people of Guyana said to me, "We have our land title, but we want to make this land safe for generations to come. How do we do it?" They invited me to their territory in the deep south of Guyana. In this situation, it's no good sitting in a room and asking people to instruct you as a lawyer. I was fortunate that the former head of the army, Major General Joe Singh, a very dear and trusted friend of the YY, said to me, "Go for a walk." So we walked. We held our meetings on the trail, by the river, in the forest, and everybody talked to everybody else. And after 6 months, the YY used the Amerindian Act to create an indigenous protected area over the entire 2,300 square miles of their territory. One young YY ranger said to me, "This is our land. This is our mother. We take care of her, and she gives us everything we need." This, I think, is a beautiful example of living lands in action. Now, it's been a happy story so far. Frogs in teapots, collective land rights, spiritual values, protected areas, living lands. In 2015, disaster hit us. ExxonMobil said they had found oil offshore Guyana. The oil curse has hit us. Guyana, it's very special. You can get beautiful sandy beaches and blue seas all over the world. But we have something magical: mud. We're in the Amazonian Orinoco influence zone, the longest mud coastline on the planet, and it nurtures incredibly rich marine life. Vast fishing grounds, shifting sandy areas where endangered marine turtles lay their eggs. The ocean is home to thousands of species, from tiny pteropods less than a centimeter long to giant sperm whales, the creatures with the biggest brains on Earth. What's that got to do with living lands? The call at paragraph 14 recognizes the importance of the ocean and incorporates the Commonwealth Blue Charter. The Charter's principles are a fair, inclusive, and sustainable approach to ocean protection and economic development. You can't drill oil and protect the ocean. It's not possible, not on this planet. Oil drilling is killing our ocean. Chemical pollution, noise pollution, light pollution, ship strikes with marine animals, greenhouse gas emissions, ocean acidification. The oil company is allowed to dump 4,000 barrels of sewage into the ocean every day. That's going to be 1.2 billion gallons of sewage over the life of the first project. Fishermen say they can't find fish. The worst case scenario is a deep water well blowout that could exterminate marine life. But ExxonMobil says the winds and the current will take the oil from a blowout northwest into the Caribbean. My sisters and brothers from the Caribbean, please talk to me. Oil could kill marine life in the Caribbean Sea as well as the Atlantic Ocean. Guyana is violating every principle of the Commonwealth Blue Charter. In the call, the heads of government of the Commonwealth say that the Earth's climate is changing at an alarming rate. We know what's going on. Greenhouse gas pollution from fossil fuels is causing global overheating, destroying the climate system, and bringing extreme weather that is destroying lives and property. Oil and gas production offshore Guyana is contrary to the call for living lands. What could be or would be an appropriate response as a lawyer? Different responses. My own response has been to file 6 cases challenging oil and gas. One of these is the biggest climate change case in the world. If we win it, it will stop 5 billion tons of greenhouse gas pollution. We're in court to stop the flaring of gas, to enforce provisions for insurance, parent company guarantees, and so on. We already won 1 case and cut Exxon's environmental permits down from 23 years to 5 years. And there will be more litigation as we fight to protect our country and our region. So when we look at the call, our responses will very much depend on the situation in each of our own countries. So may I close now with something that is available to all of us, specifically as lawyers, no matter where we are. A group of prominent lawyers are taking action in solidarity with all those on the front line of the climate and ecological crises. They won't support new fossil fuel projects, and they won't take action against climate protesters exercising their democratic right of peaceful protest. And they say climate change results in climate injustice, in which the people who are most affected, and they generally mean the global south, have done the least to damage the climate system. And I think this declaration is in the spirit of the call for living lands, because that call refers to climate change and the need for climate action, and it recognizes, the call recognizes that developing countries have particular vulnerabilities. The declaration is open for all lawyers to sign, and you don't have to be an English lawyer. So I would invite every lawyer here to sign the declaration if you feel that it's appropriate to do so. And I've signed it. I just want to close by saying thank you so much for your presence and for your beautiful spirit this morning. Thank you.
Hi, a very good morning to each one of you, and happy Holi. Holi, as you may know, is the festival of colors. So if any of you would like to sort of venture outside, I suggest that you shed your formal business suits and attire, because you're likely to be smeared with red powders and greens and yellows, etc. But do enjoy it. It's a very, very popular festival in North India and in Western India and Goa as well. Well, there were 3 communiques which were issued, or there was 1 communique and 3 documents, sets of documents which were issued last year at Rwanda in June 22 at the CHOGM. One was the Commonwealth Living Lands Charter. The second was a declaration on sustainable urbanization. And the third was a communique on the delivery of a common future issued by the heads of government. And I looked back at 1983 when CHOGM was held here in Goa. And the Goa Declaration is broadly quite silent insofar as environmental and sustainable development issues is concerned, except on one aspect. You had the United Nations Convention on the Law of the Sea, which had just been signed in Jamaica. And so there is a call to nations issued in 1983 from the Goa CHOGM saying that please sign up, otherwise we will lose on this wonderful resource which is to be inherited by all future generations. The evocative language of these charters also reminded me of the perils occasionally which visit judges. So we have a judgment of the Indian Supreme Court in 1989, which really captures in its opening paragraph the spirit of living lands. And it quotes at great length, and it says that we will not edit this a beautiful missive, and it is addressed by the chief of the Native Indian tribe of Seattle to President Franklin Pierce. And so they quote it in extenso in this judgment, which is called the Taj Hotel case, the Calcutta Taj Hotel case. And then it goes on to decide the case. And lest you be remiss in reading Indian Supreme Court judgments, they quote the very same passage in 2002 again in a second judgment. And should High Court judgments be your preference, there are 5 High Court judgments, or maybe 6 High Court judgments of different High Courts from the country, which quote this letter, evoking the spirit of the birds and the wildlife and the lands. And then it was left to Mr. Karthik Shankar, a field biologist, who in his brilliant book about preserving sea turtles, and it's titled From Soup to Superstar. And he reminds us that this entire quotation is to be attributed to Ted Perry, a young film producer in the United States. And so he exposes this fabrication, and it's now left to us to see whether the Supreme Court sort of furiously backpedals and corrects itself, or whether we're going to have this little passage on living lands which remains in the Supreme Court judgments. 3 points. The first, I thought I would just update you in terms of developments in India on with respect to the Declaration on Sustainable Urbanization. And here we have a fledgling jurisprudence developing with regard to the right to the city. So the right to the city is a very, very important right in the Indian context. We have tens of thousands of people who migrate from rural areas in search of better jobs, better education, better health care, water, and other amenities which one associates, aspirational activities. And so the conflict which arises in the India context is that what do you do when you have such a large number of persons moving into your cities and you do not have the essential housing infrastructure, and the best of plans are not able to cater to that. So the Delhi High Court recognizes the right to the city and recognizes that in each one of us, for each of us city dwellers, it's been some generation, someone, a grandparent or a great-grandparent who's moved to the city. And we cannot, therefore, ignore the present generation. And the court uses this right to the city to balance as to whether persons who are residing in slums or shanties can be removed, forcibly, without providing them with some chance of rehabilitation. So that's a step forward in terms of the Delhi High Court. We have to see as to whether it sustains before the Supreme Court of India. The second point I wanted to just draw your attention to, and perhaps many of you are aware of it, is the Commonwealth Climate Law Initiative. So the Commonwealth Climate Law Initiative commenced sometime in 2015, 2016. And it was prompted by the governor of the Bank of England, who said that, look, the way I look at, the listed companies and the roles and responsibilities of directors of companies, there is perhaps a positive obligation, perhaps, across jurisdictions, to really be aware as corporate leaders as to what the impact of your businesses is going to be insofar as climate change is concerned. And so CCLI went about requesting, and I learned a new expression then, not pro bono, but low bono. So they went across several jurisdictions on this sort of low bono mission, and they've garnered opinions from a leading counsel in Australia, in Malaysia, in Canada, and it sort of also expanded to beyond the Commonwealth, in a manner of speaking, to Delaware and several other, Hong Kong, Singapore, several other jurisdictions where what they have done is that they've set out the law and put it out in the public domain in terms of the liabilities of corporations and those responsible on the boards of these corporations, whether they can be sued, whether what the extent of their liabilities are, how they can be sued. And this is, I think, a beginning in terms of ensuring or enabling lawyers answering this call in terms of climate change and for living lands. I'll just move from living lands in terms of the human context and probably take a hint from what was mentioned with regard to other creatures who share our planet with us. And if I have the time, I'll mention the second case, but I'll certainly do the first one. So we have a judgment of the Indian Supreme Court in 2012, and it goes by, it's popularly known as the Asiatic lion case. So we have Asiatic lions in the western state of Gujarat, which is a little bit north from up here, along the coast, along the west coast of India. And the lion population had fallen to below 100, well below 100. I'm happy to say that the latest census in 2022, the population has climbed to over 700 now. So that's been a success story. But there was a petition and a policy of the government of India, which was that the lions must have a second home. So they have Gujarat, and let's have a second home. So there was an area in Madhya Pradesh, which is a neighboring state, and this entire wildlife sanctuary was cleared of human habitation and villages. The villages were rehabilitated outside, and it's called the Kuno Wildlife Sanctuary. And so you had Kuno, and now all that was left was that you move these lions, or a pride of lions, to Kuno. Kuno was ready with its prey base and everything, just waiting to receive the lions. But Gujarat would have none of it. And so they resisted. And eventually, the government of India, out of despair, decided that let's reintroduce the cheetah. So you have the cheetah, and you sort of look around, and you have a friendly Commonwealth nation in Namibia. And so in 2012, we have a situation where we have these dozen or so cheetahs in Namibia waiting to board with their boarding cards in hand to arrive in India. And Kuno is all dressed up and ready to receive them, which is when the amicus curiae moves the Supreme Court of India in this lion shifting case and says that, wait a minute, these are exotic aliens. This is not the Asian cheetah. The Asian cheetah is down to 50 in the mountains in Iran, and you can't bring this. And the Supreme Court of India accepted that argument. So the way Gujarat looked at it was quite interesting. They didn't want to send the lions. And, if the cheetahs came, it would take about at least 2 decades for the purposes of establishing themselves and having a route over there in Kuno. So Gujarat was pretty pleased with it. But the Supreme Court accepted the amicus's submissions. That was Mr. P.S. Narasimha, who will be visiting us on the 9th. Now, of course, his arguments were so persuasive that he's been sort of elevated to the Supreme Court of India, and he's now a justice on that court. So he was able to persuade the Supreme Court, and the Supreme Court said that the move to bring cheetahs from Namibia is arbitrary and capricious and will not be done. Now we shift to 2020. By now, the Chief Minister of Gujarat is the Prime Minister of India. So, there's a pretty a shift in the dynamics. And so what do you do with this order of the Supreme Court? So you have the Ministry of Environment and Forests and certain other groups, actually. The Ministry of Environment and Forests supported this, said that please allow us to bring in a few cheetahs on an experimental basis, and the expression they used was at a suitable location. So it was all delightfully vague, and the Supreme Court didn't quite realize that it was backpedaling on its own judgment, which had said that this was capricious and arbitrary, and said, all right, go ahead and bring it on an experimental basis. So we had last year a complement of 8 cheetahs which arrived from Namibia, and we then had 12 more. So we now have 20 cheetahs at Kuno Sanctuary, the sort of experimental kind of area where we are doing. So that's sort of extending it in terms of the living land. The second case, which I just point to, which is, resulting in a huge, which lands up in the Supreme Court of India, because we don't seem to be able to work our wildlife laws and our federal structure without a push or a nudging from the Indian Supreme Court, was with regard to elephants. Elephants, and this is across India, the protected areas which we have, which is about 5% of the territory, is too small to hold our wildlife populations. So whether it's elephants or tigers or snow leopards, some of them are, of course, within the protected areas of sanctuaries and national parks, but inevitably they extend beyond it. Their range extends beyond it, and that's the only way to contain them. So this results in a sort of a conflict situation from time to time. And so we have a judgment in 2020 called the Elephant Corridor case. And it's a really interesting judgment where the Supreme Court says that, look, we have to protect these corridors and leave them free for elephant movement up and down, because the elephants are following the rain and consequently the vegetation. It's an ancient pattern that they're following. And so a large number of structures, including hotels, which had come up in this band, in this elephant corridor, were directed to be removed. This is, of course, going to have huge repercussions with climate change. Because as you know, with climate change and changing weather patterns, the vegetation is also going to change. And the elephant corridors and all the other corridors are going to change as well. So we're having this enormous challenge in terms of living lands and with regards to how are we going to hold and accommodate these various populations without having conflicts with human beings. I'm sure those are experiences elsewhere in the Commonwealth which you may be able to share. So I'm very, very grateful for your time. Thank you very much.
Well, thank you so much to our three excellent speakers. The concept of living lands has really come to life, I think, where we've been looking at things as varied as the cases involving Torres Strait Islanders in Australia, the turtles and the oil industry in Guyana, and finally lions, cheetahs and elephants in India. I think this illustrates how wonderful the Commonwealth is, that it represents all these ideas, and indeed how flexible the common law can be in providing us ways of challenging the threats. And that's what I think the Commonwealth Charter is really all about. But I think I can see Luis Franceschi. Yes, is there a roving microphone around? He is I think the Assistant Secretary General of the Commonwealth, and I'd like him just to say a word about where the Charter's got to in the plan. Perhaps you could like to come up to the stage if there's no. Thank you very much.
It's dangerous to give a lawyer a microphone and a willing audience. We can be here until tomorrow. Very quickly, Chair, thank you very much for asking me to do this. The Charter on Living Lands was agreed and adopted by leaders, heads of government at CHOGM in June 2022. It's a follow-up on the other side of the coin of the Blue Charter that had been signed in 2018 in London CHOGM for the care of the oceans. So basically, you cannot care for the oceans if you do not care about the land that pollutes the oceans. So it's the other side of the coin. As the Chair explained very well, it's a series of acknowledgements by the heads, but what really we wanted, and we were asked by you, many of the Commonwealth accredited organizations, was to make the leaders commit to the implementation of the 3 Rio Conventions. We could have gone for 20 Rio Conventions, and we are always making declarations, but commitment is rarely there. So the idea of the Charter is commitment to implementation. They asked the Secretariat to come forward with an implementation plan, and we are very much aware that this implementation plan has to be practical. So this, with the COP27 last November and COP15 in Montreal last December, has been put together and assembled, will be ready by the end of before the end of this month, to be circulated among the governments, the 56 member countries, and the accredited organizations that are participating members, and CLA is one of them. So we hope to get all the input from the countries, from our partners, also UN, UNDP, UNEP, etc., and then come up with that implementation plan, which will be actually an action plan, action-oriented plan for implementation, hopefully. As we say in Nairobi jokingly that we drive on the left, but the people in Isiolo, northern Kenya, say we drive on what is left. So we do not want a word of what is left, but the idea is to have precisely that commitment and to stop non-regenerative techniques. Thank you. I hope that's sufficient.
Thank you so much for that. I think we need to think actually seriously about what the Commonwealth Law Association can do to contribute to this important process, because I think sort of putting detail into the implementation plan so it really has teeth is something which, as you've heard from our speakers, some of the people in this room are very well fitted to do. So I think perhaps some thought can be given by the CLA committees to how that we could actually contribute positively to this process. So we can talk about that later. I think at this stage, probably I'm going to have to bring this part of the session to a close, because we, as I said, I hope somewhere here is the president of the Law Society of Sabah to speak about what they're doing. I look around, yes, perhaps there. So, and I think there's a video to go with that. So perhaps just one last round of applause for our excellent speakers, and thank you for attending.
Thank you, Chair. Good morning. My name is Stephen Thiru. I'm from the Australasia Hub. The CLA has 4 hubs. Australasia is one of them. I'm here to speak to you briefly about our next in-person event, the next CLA in-person event, and that event will be in Sabah, Malaysia. It is called the Borneo Rainforest Law Conference. It has been an event that has been organized by the Sabah Law Society, and we'll be working with them on it. It is fixed now for the 26th to the 29th of February 2024. Here with me is Mr. Roger Chin, the president of the Sabah Law Society, who is going to sing a song? No? Oh, who's got a video to play about the event. Roger.
Thank you, everyone. Thank you, Stephen. This is basically a short promotional video to hopefully beguile you and attract you to the upcoming conference. Thank you. Hope that is sufficient to attract all of you, and that's only a short snippet of what is available in Sabah. The conference will have topics on living lands as well as native customary rights. So with that, I'd like to welcome all of you on behalf of the Sabah Law Society as the local bar to please consider and please actually do make a booking and come to Sabah, and we welcome you then. Thank you very much.
Thank you. That was slightly shorter than I was expecting, but none the worse for that. And certainly, those of you who've been to Sabah, I have indeed a little invitation to try and get there. We do actually have 5 minutes left for if there are any questions or points of discussion. Yes, in the front row, is there a microphone? Is there anyone out there who are? Good, well done. Would you like to introduce yourself and then?
Claims. That's just one aspect of what you said, Fiona. But a lot more fundamental issue, and I say this, it's a huge political issue, and it's a topical issue in Australia as well. And this is just my personal view. It's not the view of my government. Your Prime Minister was there recently in Port Moresby. But my question is, and this is coming from the heart. Now, you're talking about, you have labeled people as First Nations or from Canada or from Australia. I'm not sure where that language came from, that the First Nation language or those words came from. The traditional inhabitants of Australia deserve some recognition. Why is it that Australia continues to deny human rights of the indigenous Australian to be part of Australia and be a citizen of Australia and be considered such under the Australian Constitution? And you asked the question, what is the Commonwealth Lawyers Association doing to enhance that? And so that is my question. What is the Commonwealth Lawyers Association and the Lawyers of Australia doing to enhance the Indigenous people's rights to be citizens of Australia? Thank you.
Perhaps, Brian, you want to respond? And then I'll respond to what's happening in Australia at the moment.
Yes, if Fiona can respond from the Australian perspective, but just from what is the Commonwealth Lawyers doing, we have created an environmental committee. Indeed, some of the members are here. We very much want to learn what is required and then to implement that in whatever way we can do. This session was, of course, created by the CLA to draw attention to as wide an audience as possible to these critical issues. And we formed specifically one of our first special interest committees was the Environmental Committee. So we simply would say what we are doing is we're starting on an important first step and journey to do something. What we will do in terms of implementing what the Chief Justice of Papua New Guinea has just said in respecting the rights of Indigenous people. I have personally a project that we started along with Stephen Tiru on Indigenous people's land rights and to give greater emphasis and protection to those. So there is an interest in the CLA to become more active in these areas, and I'm sure that all of you will see that greater activism coming through. So I can assure you that we take the message, Sir Gibbs. We thank you for that challenge and that question, and the CLA, I am absolutely sure, will respond.
Thank you, Brian, and thank you, Chief Justice, for the question. Standing on the shores of Sabah, I have looked across the water to see the shores of Papua New Guinea and the beautiful coastland and riverway, the large rivers that you can see from the Sabah shores remind us how close the cultures and lands of the people of Zendathkes and the Papua New Guinea are. So thank you for the question. In terms of what Australia is doing, this year we are undertaking a referendum later in this year to amend our constitution. The purpose of the amendment will be to recognise Aboriginal and Torres Strait Islander people in our constitution and to create a body that will be able to make representations directly to government, and hopefully also, if the wording is correct, to our executive about matters that relate to them. This is seen as an important first step towards self-determination and the negotiation of treaties with Aboriginal and Torres Strait Islander peoples. The people of the Torres Strait are in a slightly different position to mainland Aboriginal people because they are self-governing by way of their authority and their councils already, but the intention is to create an ability to speak directly to power. And that decision, that choice to recognise those things in our Constitution is something that, in my view, all lawyers should support as a necessary way to empower our First Nations people. I use that language deliberately because I'm counsel assisting the Truth and Justice Commission in Victoria. That's the language we've been asked to use when describing our First Peoples. But recognising in many countries like the Torres Strait, in many places like the Torres Strait, there have been many generations of people coming and going to those islands, and recognising their continuous inhabitation of those islands for more than 60,000 years. So that's what Australia's doing. We're on the pathway to truth and treaty, and truth-telling involved in these sort of commissions of inquiry. What can the lawyers do? Well, they can come to the session that Melinda is involved with at 5 p.m. The Climate Justice Committee is meeting today at 5 p.m, and I'm sure we'd all appreciate seeing you there and hearing your contributions to what can be done individually and as a group. Thank you. Thank you, Chief Justice.
Thank you for that. Perhaps time for just one more question, if anyone has a topic. There's...
Good morning, everyone, and thank you very much to the speakers for the presentations. Very insightful and definitely enjoyable stories there, Shyam, again. Thanks a lot. So just one particular question to Fiona to begin with. I'm from the Seychelles, Angelique Pupono, and when it comes to litigation in the context of being from a small island, there's a tendency not to tend to want to sue a government from a small island because much of sort of the contributors, the more significant contributors, are from outside. So I'd love to hear your point of view on cross-border litigation. My own comment on this is sort of from my research, I found that it's perhaps better to have allies within countries like Australia to take up these cases as opposed to going for cross-border litigation. Keen to hear your view on that. And to Melinda, super interesting. And I think I work in the international space with the Alliance of Small Island States. And when I think of things nationally, I'm totally aligned with you. But then when I sort of put on my international hat, part of the negotiations that we're doing is thinking about carbon budgets for the world, right? So given that there's historical responsibility by other countries who have polluted for so long, is there a perspective that is somewhat acceptable that perhaps Guyana does have sort of space within the global carbon budget to exploit to an extent? Or is that not the right balance if you place it sort of from a national context as opposed to an international context? Would love to hear your reflections on that. And maybe from an equity perspective, a global equity perspective. Thank you.
Right, well, I'll ask Fiona to respond briefly, and then Melinda, and then we'll end the session.
It's completely understandable that in a country like Seychelles, there's a concern that a claim against government would not be successful or would not be very helpful in terms of securing mitigation and adaptation measures. It's like telling the government that has a very small contribution to climate change and has been affected by the global actions of others that they are responsible for the damage that the citizens have suffered. I think Australia's in a different case, and this feeds into your second question too. the current government seems to have accepted that there's a need for greater cooperation and collegiality with certainly islands in our region because of the impacts of climate change, but they're still maintaining that, well, we only contribute 1.something% of the total global budget, greenhouse gas budget, so we're not responsible for all of it. And that's a defence they've taken in our case as well. So I think it's important to emphasise for those countries who have made a contribution to the global situation with greenhouse gases that 1% still adds up to 100% when all of the nations are combined. And yes, we need to address the biggest emitters, but also we need to address the sectors that are the biggest emitted, the extractive industries, for example, fossil fuel, transport, and so on. So my sense is that a country like Seychelles that will be impacted by climate change very heavily is probably more interested in looking at the responsibility of other nations to the contribution of greenhouse gases and the rise in temperatures, and pressing its own government to take a fierce stand on that. And I can remember years ago meeting, I don't know if we have any Bangladeshi colleagues here, I remember years ago meeting the foreign minister for Bangladesh, who was then off to one of the COP meetings, and literally she was going to say to COP that a 1 degrees change in global temperature meant the inundation of 150 kilometres of coastline, at least, for Bangladesh, and the displacement of millions of people. And when I was there, we saw this with a cyclone in the bay that displaced millions of people to Dhaka, where they were environmental refugees sleeping and dying on the street in front of our eyes. So that was more than a decade ago, and the voices of Seychelles and the voices of the government in speaking about these impacts are so important and must continue to be heard by the rest of our nations in all international fora, because they really can tell the story of those impacts. And the rest of us, you know, what are we going to crawl into our concrete bunkers and pretend it's not happening to us and live some sort of virtual reality where images of forests and cheetahs and elephants are played on screens so that we remember how to be human beings? Of course not. We need to act urgently, individually and as nations, to turn this around.
Thank you. I love that question. There is no carbon budget. The safe limit for greenhouse gas concentration is 350 parts per million. We are now at 420 parts per million. That's dangerous. That's life-threatening. There is no carbon budget. In terms of the equity, whether Guyana has a right to use oil and gas, absolutely not, because nobody has a right to keep on emitting greenhouse gas. Now, there is an equity question here. We're talking about two different things. All of the debate today focuses on emissions, on the flow, but the big problem is the stock, the stuff that's been put up there for the last 100 years, and that's what has to be removed by the countries who put it there. We're a carbon sink. We're currently taking out 150 million tons of greenhouse gas every year. We help the world to breathe. And last year, Guyanese citizens wrote to the president and said, we know you're on your way to COP, have a wonderful time, and when you're there, one of the demands we want you to make is that the world pays Guyana, the emitting nations, the rich nations, the fossil fuel economies, pay Guyana $80 a ton for the greenhouse gas that we're taking, carbon that we're taking out of the atmosphere. So we don't need oil and gas, but we do need and demand and require and want and ask for the recognition that the carbon we're taking out of the atmosphere from our forests, 80% of Guyana is still forested, that equity says Guyana should be paid for that. And we said the money should go directly to the people not to the government, because the forests are owned by the people, not by the government. They're owned by the state, and the state is the people. And that where there are forests on Amerindian lands, that money goes direct to those communities again. That's not what has happened, but that's what people have said that they want. So in summary, no carbon budget. We've got to deal with the stock, not just the flow. And rather than Guyana doing oil and gas, people have said, pay us for taking the carbon out. Thank you very much.
Well, I think on that note, it's a very appropriate point to finish this very interesting, stimulating session, and thank you all for attending.